Hello, everyone. This is a public service announcement for the Hood River County School District, and today we're going to be talking about parent rights as it relates to special education. So, in this presentation, I will highlight some key facts about it, but I will not touch on everything. So, at the end of the slideshow, I will put a link to the packet that is provided by the district. So to start things off, the definition of a parent. So a parent is a biological or adopted parent, a foster parent, a legal guardian, a surrogate or parent appointed by school or juvenile court, a grandparent or step parent, or included in that is any relative that is living with the child that cares for the child. So as we move forward, when we say parent, these are the things that we're talking about. General information. So, IDEA, which is the Individuals with Disabilities Education Act, states that parents must be provided with written explanations when their child is receiving services. Ages 3 to 21 are who are eligible for services and have safeguards, and then a different set of safeguards are given to children from 0 to 5, and that's by the ODE, or the Oregon Department of Education. This applies to any parent with a child who attends school in Oregon with disabilities. Consent, what does it mean? So consent is your permission, and what consent is needed for is an initial evaluation and to start providing services. So consent is needed for an initial evaluation of the child. Separate consent is needed to begin services. Refusal does not necessarily block an evaluation completely because the school is obligated to locate and identify students with disabilities. So mediation may be needed if the school identifies a student but the parent has refused consent. With the school being obligated to locate and identify, they're going to continue to do that, and the parents may need a mediator to come in if they have already refused. Confidentiality. Your child's personal records are kept confidential. All identifiable information is removed from the records when necessary. So that may be when the services are terminated. So if the student no longer needs services, the identifiable information would be removed before they are discarded. And it could also be when discussing information with other professionals that are not included on the team. And you have access to these documents, and the school must respond within 45 days. Fees. A fee may be charged if it does not prevent you from accessing records. This will not deter you from having access to your record. So basically, the section on fees just discusses that it won't keep you from your right to see the records about your child. Okay, so fees will not be a deciding factor. Safeguards. Each participating agency must protect the confidentiality of personal identifiable information at collection, storage, disclosure, and destruction. So when the information is being collected, the confidentiality is there. When it's being stored, that needs to be in a confidential safe location. Disclosure, so maybe when the student graduates or maybe when they stop qualifying for services, and then the destruction stage as well. So at every stage of this process, your information is kept confidential and safe. Filing a state complaint. So there's a lot of information that goes into filing a state complaint. You need to show that the district has, or public agency, has violated Part B of the IDEAS Act, or is implementing regulations, or it's implementing regulations, sorry. The facts on which the statement is based, the signature and contact information for the party filing the complaint, if alleging violations regarding a specific child, the name of the child, the address, the name of the school, in the case of homelessness, any contact information, a description of the nature of the problem, and a proposed resolution. So although there is a lot that goes into it, Filing a state complaint can be important because if your child is not being treated fairly or receiving the services that are needed, this may be the process to get the school district behind you. The resolution process, so within 15 calendar days of the complaint, the school must schedule a resolution meeting with the affected members. And so, although 15 days can sound like a long time when it's your child, it can be the best way to get things moving. File a state complaint, the school is obligated to have to go through the resolution process. So there is some support given there as well. Disciplining a child or children with disabilities. So while this is a case-by-case situation, the student may only be removed from class for no more than 10 days for violating code of conduct. So the idea here is that we're keeping students in class even if they are violating some sort of code of conduct. So the goal is to keep them in class. So that's what the disciplining children with disabilities covers. Other information discussed in the packet are private school placement and payment, disagreements and mediation, so a little bit more details about that, mail and language communication, so mailing documents and preferred native languages, due process hearings and appeals hearings. So there are a lot of other sections within the packet. And like I said, at the end of the presentation, I'll provide you a link to that so you can have more access if you want it. But those are some of the other key points that are in the packet. So for more details, visit that website. It's the Oregon Department of Education. Please feel free to contact the school if you have any further questions on the details discussed today. I hope that this was an informative public service announcement for parents' rights for children with disabilities and in special education. Thank you for your time.